Mr. Johnson, my name is Emily Rapp. I'm a representative for Insurance Branch. As you know, Insurance Branch is in the business of consulting for disability advocate firms and disability law firms, specifically dealing with Medicare entitlements and benefits for their clients. I know that attorneys owe specific duties to clients. I understand that you have researched and have developed opinions regarding those disability firms' duties as they relate to informing their clients regarding their entitlements and benefits with Medicare. Is that true?
That is exactly right, yes.
Can you explain a little bit more about that?
I'm happy to, but first let me do what a lot of lawyers do and provide a little bit of a disclaimer. The information I'll give you in answer to your questions about this subject comes across as legal advice. And I am a lawyer, and I've researched these questions, and I've developed conclusions regarding those questions. But it should be clear that I'm not providing legal advice to any one person in particular in this particular video presentation.
Fair enough. So may I just ask you, do you think disability firms have a duty to inform and advise clients about Medicare entitlements and benefits?
I do think they have that duty. I've come to that conclusion by understanding the industry and researching the ethical question of lawyers' duties to disability clients.
And why would you say they have that duty?
The scope of representation of a disability advocate or attorney is usually to get a determination of disability and an award of benefits. When a client receives an award of benefits and they receive that in writing from the Social Security Administration, generally there's a description of the fact that they'll be entitled to Medicare entitlement and benefits, usually approximately 2 years down the road.
Mm-hmm.
I've concluded that because that is referenced in their award, it is incident to the representation that the disability advocate or attorney is providing. And therefore, it's the attorney's duty to provide information and advice regarding Medicare coverage.
Can you explain how a disabilities firm's duty related to Medicare arises?
Yeah, the first principle to talk about is the engagement.
What exactly do you mean by engagement then?
An engagement is like a contract. Mm-hmm. A lawyer puts in writing what he or she expects to do or not to do for the disability client. We call it an engagement letter or an engagement agreement. And that agreement defines oftentimes the scope of the lawyer's representation.
All right. Is a lawyer's scope of work for a client defined in any other way?
It can be. There need not necessarily be a written engagement agreement.
Okay.
In that instance, the engagement becomes, what does the client expect?
Mm-hmm.
And it can't be just they expect you're my lawyer, but it's what the client reasonably expects. Oftentimes, if a lawyer commences work and there's no written engagement letter, there might be a reasonable expectation by the client that there is now an attorney-client relationship. So the relationship need not be reduced to writing. We think it should be,
mm-hmm.
but in all instances, it necessarily need not be. So in summary, what this means in the context of what we're talking about relative to Medicare entitlement and
mm-hmm.
Medicare benefits. If there's a written agreement that states that would be part of the representation, then it becomes a duty of the lawyer to inform and advise on Medicare. Or otherwise, if the client reasonably expects that the lawyer will advise in connection with Medicare entitlements and benefits, then it becomes a duty. And that's really what I'm talking about when I suggest disability advocates and attorneys
mm-hmm.
have a duty relative to Medicare entitlement and benefits, is the client can reasonably expect that the lawyer will provide that information and advice.
So it's a question of agreement, And an agreement can arise either explicitly or based on the facts of the situation. Is that right?
Yes, that's exactly right. It comes down to the fundamental principle on whether it is explicitly or implicitly expected by the client to receive information and advice regarding Medicare benefits.
So that's it.
Well, that's it in a nutshell. But in the context of the SSDI process, it's a little bit more complicated than that. There's really three complications. The first complication is sometimes the engagement is a little vague and it doesn't specifically reference Medicare entitlement and benefits. For example, the engagement letter might say, I will represent you on all matters incident to your SSDI benefit. Well, I'd suggest that Medicare coverage is incidental to the SSDI award and benefit. So a lawyer needs to realize that. Also, some lawyers in this space I've recognized simply use the Social Security 1696 form for their engagement. That form does provide some specific references relative to termination of the representation, but again, you have a situation relative to what the client expects.
Right.
So for example, you're a disability firm, your office receives a phone call from a client that you represented 2 years ago. That client calls and says, hey, I'm looking at my award and it says now I'm entitled to Medicare coverage. Can you help me with that? Well, do you have the answer? That's the second complication. Does the lawyer have all the information related to Medicare entitlements and benefits so they can sufficiently answer the client's question?
I can see how the lack of clarity and engagement can create a lot of uncertainty about who's taking care of what.
Exactly. And then there's the second complication. And that's the reality that there are regulations promulgated by the Social Security Administration imposing duties on disability advocates. In addition to that, lawyers have rules of professional responsibility, rules that require them to act with diligence, to act in a timely fashion, and to act diligently in connection with their representation of their client. All of those rules play a role in coming to the conclusion that I've come to, that a lawyer has a duty to inform and advise regarding Medicare entitlement and benefits.
Can you give me an example of an SSA regulation that might relate to a disability representative's duty to inform and advise a client on Medicare entitlements and benefits?
That's a good question. And consider this one. One such regulation requires a disability advocate to, quote, maintain prompt and timely communication with the claimant, which includes reasonably informing the claimant of all matters concerning the representation, consulting with the claimant on an ongoing basis during the entire representation period, and promptly responding to a claimant's reasonable request for information. That is a loaded rule. And that is an example of why I've concluded that a lawyer or an advocate has a responsibility to inform a client on medical entitlement and benefits. The fact is that 2 years down the road, a client is going to be entitled to Medicare. And that client deserves, as part of the scope of the representation of the advocate, to understand what that means.
Yeah, that makes sense. Are there any other complications relating to disability advocates' duty to inform and advise clients regarding Medicare entitlements and benefits?
Yeah, there's one more very important complication, and that relates to the client's knowledge of the Medicare entitlement and benefits. Disability attorneys and advocates are generally very competent in their work relative to determining the disability and helping the client obtain an award.
Mm-hmm.
But very few, I've learned, really understand the ins and outs of Medicare coverage.
So what does such an attorney do to satisfy that duty we're talking about, the duty to inform and advise clients about Medicare entitlements and benefits?
A disability advocate or attorney really has two options to adequately inform and advise a client about Medicare. One option is to be an expert at Medicare entitlement and benefits and all that relates to that. That may sound easy, but let me ask you a question, Emily. Do you perceive the laws, rules, and regulations pertaining to Medicare eligibility, etc., deadlines and all that goes with it, to be simple or complicated?
Well, I perceive it to be extremely complicated.
It is complicated, exactly. And that's why a practitioner ought to be cautioned about being blindsided about the duty to do it. Would you just guess at some of those answers to those questions regarding Medicare?
Absolutely not. I'd want to be more confident.
Yeah, and would you even want to research them for the first time when you get a phone call from a client asking about it?
No.
I've learned that most disability advocates and attorneys really don't have those questions, and so that really isn't an option. Even though it is an option, it really isn't a great option because they just don't know about Medicare.
Is one option possibly for the disability representative to simply refer their clients to the Medicare hotline?
In my communications with practitioners, that's something that they do. They'll get a phone call and they'll tell the client to call the Medicare hotline. I think there's a real problem with that. And the problem is they are now relying on whoever answers the phone at Medicare to provide accurate information. And you would think that's a given, that they'd provide accurate information, right? But we've learned, and I've actually been on phone calls where the Medicare representative asks the simple question, "Are you 65 years or older?" And the disabled person says, "No, I'm 35. And the Medicare representative says, "Oh, Medicare is for 65 years and older, you don't qualify." Immediately you've got poor advice that could have lifelong ramifications for this disability client, right? So while it's an option to call the hotline, it's not the best because a lawyer can't rely on the accuracy of it.
You mentioned a second option. Now, what would that be?
The second option is one that I would suggest is the best option, and that is to retain a third-party consultant that knows everything about Medicare coverage, that knows everything about what the client is entitled to and the benefits the client may obtain vis-a-vis a Medicare policy. Having a third-party consultant makes sense because then the lawyer can know for certainty that the disability client is obtaining the right information. Another reason that the insurance branch model is particularly appealing, in my opinion, is that it not only provides the lawyer peace of mind that the client is getting the right information on Medicare, but it also enables the lawyer or the advocate to monetize teaching the client about Medicare, because insurance branch has a model that it will give a referral fee to the advocacy firm or law firm if in fact they provide these client references to have insurance branch contact. So in other words, the advocate or attorney, number one, is able to ensure that the client is fully informed and advised on Medicare, and number two, receives a bit of compensation in connection with that Medicare advice.
Well, thank you so much.
You bet, my pleasure.